explain to me, to the audience, what's going on? What's the EU up to, and should we be worried?
Well, thank you very much for having me. This is effectively the latest in a series of infringement actions we've seen from the European Commission that actually date back to 2020. So this was when, you might remember, the UK first proposed clauses that would deactivate the Northern Ireland Protocol in what was the Internal Market Bill. And of course, the legislation we see before Parliament now, the Northern Ireland Protocol Bill, would create that power for ministers again. So today, the European Commission has decided it's the appropriate time to pursue infringement actions.
And, I mean, are these going to get anywhere? Because my understanding, having sat in the European Parliament, is the EU loves an infringement action. They churn them out at a rate of knots. And Britain has actually historically been the best country at being able to stand up against some of the ECJ's rulings.
Well, there's no doubt that this was the start of a process rather than the end of a process. We won't be having a great courtroom drama in Luxembourg tomorrow. What we have instead is the UK government now has a period of time in which it can issue a reasoned opinion in response to the European Commission's claims. And I think you're right to point out that a lot of the time these infringement actions, they serve a political function as well as a legal function. They're a means of almost playing quite a strong hand in negotiations with a member state in terms of trying to deter them from actions that could infringe EU law. So I would say we don't have a courtroom drama around the corner just yet.
Yeah, interesting. And I'd imagine it's to get the chorus jumping up and down talking about breaking international law. But our own Attorney General said that we have solid legal grounds in which to invoke Article 16. That breaks the whole protocol, basically, if we wish to, based upon it creating environmental, social and indeed economic prolonged problems. Do you agree with her?
I'm glad you asked this question because this has been a mainstream of work at my centre, the Bingham Centre for the Rule of Law. We've recently issued a report to Parliament in which we perhaps echo that argument and state that the UK government really should be triggering Article 16 rather than seeking to create legislation relying on an international law doctrine, which is called necessity, when there are threats to the state. Our argument is this is already there in the protocol in Article 16. The UK can make this claim. I think that there are grounds that can at least be argued that this is causing significant disruption, economical, societal and environmental. And so our argument would be you should play by the rules of the game that you've helped to set up before going to a different source. So I would agree that it would be appropriate, at least for the United Kingdom, to consider triggering Article 16.
And briefly, what do you think the EU's response would be if we did that?
Well, if the UK were to do this, again, a bit like the infringements today, it's the start of a process rather than the end of a process. What this would start or set in motion, an Article 16 notification, is a period of consultation in the Joint Committee of the EU and the UK, which is quite technocratic. It sounds quite boring, but it basically means there'd be negotiations. And then there's a series of steps before the UK might be able to take measures. But there is an emergency clause if the difficulties are so immediate that the UK needs to act. So to answer your question, it would be basically negotiations again, so it would feel like we're back in 2017 to 2019.